Hey everyone, it's Joe Kral with the Society of St. Sebastian, and again, hey, welcome to Pro-Life University. We always appreciate you coming here. And speaking of which, if you haven't subscribed yet, make sure you hit our subscribe button, and please give us a big thumbs up. And while we're at it, let's just simply say that it's a great time to go out and share these videos with friends and family, those who are more interested in getting to know the pro-life public policy issues a little bit more deeply, to understand them a little bit more. We certainly believe at the Society that the more informed you become as a pro-life advocate on these particular public policy issues, the more powerful your argument becomes. So, don't hesitate to share with your friends and family, especially those who want to get to know the issue a little bit deeper. Well, this week, what we're going to do is kind of have a part two to what we had last week. Last week, we were talking about Louisiana's law that mandated that abortionists have admitting privileges to a nearby hospital. We talked about how this is a pro-life bill, the various things that it did, morally speaking. We talked about how it moved towards a culture of life. Now, obviously, the U.S. Supreme Court came down with a decision earlier this week that was rather disappointing and unfortunate. So we're going to kind of look at this decision and critique it, obviously, because it definitely needs to be critiqued, particularly from a moral standpoint. Now, obviously, since I'm not a lawyer or a legal scholar, I'm not going to comment so much on the legality of it. I mean, we'll bring some of that in, obviously, but I'm going to primarily focus on some of the moral problems with the decision itself. Now, as you know, the swing vote was Chief Justice Roberts himself, and he did not write the majority opinion. It's essentially what would be called the plurality decision. You had 4 justices that gave, their particular opinion, and then you had Chief Justice Roberts who concurred in part with their opinion and kind of went in his own way why he thought the Louisiana law was unconstitutional. And the first thing I want to do is talk about the opinion from the 4 justices that said the law was unconstitutional. I think from at least a moral standpoint, refuting their argument is rather basic. Again, this idea that they get into with respect to an undue burden to the women's right to abortion. And that's where we got to make that full stop, if you will, because it's important to note that when we talk about a right to abortion, one of the things that we need to understand is that there's no actual right to abortion. Now, those of you that follow the Society of St. Sebastian on Twitter probably see this posted frequently from the society itself, and that is one of the things that we say is rights come from duties, right? And that's sort of a moral analysis of things. That's why we say abortion is not a right. It's because there is a duty to protect innocent human life. There's a duty to preserve human life and so forth. There is no moral duty to kill innocent human life. Like I was just saying, the exact opposite is true. Is we have an obligation, right, to protect innocent human life, to uphold human life and so forth. It's contrary to the very notion of justice, the virtue of justice, that which is due to another, right? It's that word duty, right? It's contrary to what is due to the person, since they're innocent, since they haven't committed any sort of grievous, immoral, horrible act, right? They don't warrant anything that it comes close to death. And in fact, when we talk about, the unborn human life, we talk about the most innocent. These are innocent human children that don't have the ability to do any sort of moral act at any point at this point in time in their existence. And so they are definitely innocent. So as a result, we have the duty to protect them, right? So that's why I would say it's an easy argument to say, no, right? You can't sit there and talk about a right to an abortion because there's no right that simply exists, right? It's a concocted right, if you will, right? Secondly, if we get into Chief Justice Roberts' concurring opinion, here it gets a little more tricky. He wants to cite something, a legal principle. It's called stare decisis, right? And the whole idea of stare decisis is this idea that you have precedents that set within courts, right? Through court decisions and so forth. And so, the previous court decision from, the U.S. Supreme Court, for example, sets the precedent for any other case that comes about, especially with respect to a law, right, that involves a similar sort of law, or in this case, there were two similar laws. You had the Texas case that was decided in Whole Women's Health v. Hellerstedt back in 2016. And then obviously this Louisiana case, right, June versus Russo, right, where there were two laws mandating that abortionists have admitting privileges to a nearby hospital. Now, one of the things to understand here is that in the Hellerstedt decision in 2016, they ruled against the Texas law as well. And Chief Justice Roberts is arguing that, well, this precedent sets the stage for this particular issue as well. And since we got to look at stare decisis, that legal precedent basically sets a standard, and so the law is unconstitutional. Right? It's a little bit more nuanced than what we're seeing from the other four justices. And so as a result, we got to look at it a little bit more in depth, if you will. Right. Now, let's simply look at it from a pure moral standpoint. Is stare decisis as a legal principle absolute? The answer to that question is no. It is not. We know, for example, even just from a pragmatic level, the U.S. Supreme Court has overruled itself. One of the most notorious cases where the U.S. Supreme Court has done this, all right, are the cases of Plessy v. Ferguson, which was decided in the 1890s, and then roughly 60 years later, you had Brown versus the Board of Education. These were two cases dealing with segregation. Now, in the Plessy case, they said, the U.S. Supreme Court said that segregation was constitutional. Right? Now, obviously, in the Brown versus Board of Education case, they said segregation is not constitutional. Now, here is a great example of where, where stare decisis did not take absolute, precedence with regards to this case, because they looked at the old case and they said, well, this is not wrong. This is not constitutional. This is not what the Constitution is based on. This is not what the Constitution is saying, and so forth. And so they overruled that case. And in many respects, we really have to wonder, because here is a critical issue here. What would Chief Justice Roberts do if he's presented, if let's say he was on the U.S. Supreme Court the time that Brown versus the Board of Education was being heard? Was he going to rule in favor of segregation? This is troubling from a moral standpoint. Or even a better example. What if there was a case after the Dred Scott decision where it came up with the issue of slavery again? Was he going to side in favor of Dred Scott? These are troubling sorts of things, and one of the things that we absolutely need to know is that at least from a moral standpoint, when we look at it, stare decisis is not absolute, and it shouldn't be an absolute sort of principle that guides these legal decisions. And the reason why I say that is because the simple fact is that justices can recognize that their decisions are indeed wrong, and they need to be overturned. Now, I find it troubling, especially since, one, Justice Roberts in the Hellerstedt decision was actually in the minority. He said that, Texas had a right to do this sort of thing. And then all of a sudden he sort of flip-flops. Now, if that decision was wrongly decided, right, in Hellerstedt, how is it rightly decided now? I mean, what causes this flip-flop? And you got to kind of get into his mind. You got to kind of really wonder, does precedence mean everything to him? Right? Now, obviously, like I said, from a moral standpoint, we could say that stare decisis is not absolute, and that the justices do have the obligation to right a wrong. And in this particular instance, Justice Roberts refused to do that, simply didn't do that. And so he's wrong in his decision. Stare decisis is not the absolute principle that takes place. Abortion is not a right. And so they still haven't righted the wrong with respect to, one, allowing these states to enforce these just laws, and two, addressing the injustice of Roe v. Wade. Right? So these are some real concerns that we've got to look at when diving into this particular issue. I'll be honest. Right? The simple fact is now that they have overturned the law and the court has made it very clear, now with the Texas decision that came down in 2016 and now the Louisiana decision that just came down earlier this week, that no state is going to be able to pass a law that mandates that abortionists have admitting privileges to a nearby hospital. That is dangerous policy. That is an unjust policy. We know without a shadow of a doubt, there's evidence piling on evidence with respect to how abortionists and the abortion industry run a subpar medical practice. It isn't up to par to even, in most cases, veterinary clinics. This is going to put women in danger. Not only are we going to have to deal with unborn lives being killed, you're going to also have to deal with the fact that women are going to be put in serious risk due to horrible conditions. The simple fact is that these abortionists, after they botch an abortion, do not continue the standard of care that would be required of other doctors. That is gross negligence, and that, in my opinion, is absolutely immoral. And I think it's something that I pray that can be overturned one day. Now, let me leave on a positive note here, because we definitely need to leave on a positive note. The simple fact is that the pro-life movement and pro-life organizations that push a legislative agenda are not going to be stymied by this decision. They are still going to be pushing for various types of legislation, dismemberment abortion bans, and prenatal non-discrimination acts, various other kinds of clinic regulations, parental consent laws. Florida just had their parental consent law. Yay, Florida, good going, right? And other various types of pro-life measures that are aiming to limit the various harms that the evil of legalized abortion has caused. And so they're not going to be stymied by this decision. They're going to keep moving forward. And, rest assured, trust me, there are going to be those cases which kind of push the envelope to see where the Supreme Court is willing to do and so forth with other types of pro-life legislative initiatives as well. So rest assured, the pro-life movement isn't going to be, we don't have time to be horribly discouraged. We got to move forward and try to save lives and help usher in a culture of life. So anyway, again, thank you so much for always watching these videos, guys. I really do appreciate it. And again, if you get a chance, make sure you subscribe, right? That's always a wonderful thing. Give us a big thumbs up, and we always appreciate it. And if you have any questions, don't hesitate to put them down on the comments, all right? We'll be glad to get back with you. Anyway, have a blessed weekend. Have a happy 4th of July weekend, and be safe out there. God bless.